Good morning, Your Honors. May it please the Court. My name is Mitch Raines with the Public Defender's Office, and I'm here today on behalf of Mr. Jonathan Duncan. At this point, I'd like to reserve 4 minutes for rebuttal. Thank you, Your Honor. I've raised several issues on appeal in this matter, but for purposes of today, I'm going to try and focus on only two, and that's the trial court's error in allowing evidence of prior bad acts to be introduced at trial, and the sleeping juror issue. Before I delve into those, though, I would like to address just an initial matter in the reply brief. So after I filed the principal brief, but before I filed the reply brief, it was brought to my attention that the judgments in this matter do not reflect that. I believe it's counts 1 and 2. So the felony murder and the premeditated murder were not merged. So if this court has any questions about that, I'm happy to try and address that. Or if you would like supplemental briefing, I do see that more as kind of a technical issue. But we would just ask if nothing else.
We probably would have ordered that anyway.
Okay. That was
but
my
we
thought.
appreciate you bringing it to our attention.
That was my thought, and I feel like I've seen that in other cases. I just want to try and cover the bases. Moving then to the prior bad act issue. To give a little bit of context there, Mr. Duncan did file a pretrial motion. The state filed a response. There was a hearing that was held on that. I do not think that the record contains an official order from the court on its determination from that. But at the hearing, the court did say that the prior bad act, which is kind of referred to as like a Nashville incident, that would be admissible at trial. But I do concede that it was not raised in the motion for new trial. I don't think it was otherwise argued at the motion for new trial, so unfortunately, like everything else this morning, it's under plain error. But Mr. Duncan is still entitled to plain error relief. In its brief, the state really only challenges whether a clear and unequivocal rule of law had been breached by the trial court allowing this information in. And in a footnote, it relies on a unreported case from 2013 out of this court called State versus Kirkpatrick. And Kirkpatrick, or the state's position is that Kirkpatrick says that a trial court can find clear and convincing evidence of a prior bad act based off just a summation of the evidence. And I would disagree with that.
But there was no disagreement as to what the evidence was going to be by the parties, right?
To the best of my recollection, the state gave a much more detailed summary of what the proposed evidence was, and I don't think that the defense counsel challenged that, but there was still no presentation of that proof. There was no testimony taken that day. There were no exhibits entered, no videos put in, and the trial court, when it said that this evidence could come in, it essentially found that it said something to the effect of, if you're telling me that there are going to be videos, then that's going to be clear and convincing. It
sounds to me like the trial court is saying, everybody's talking about the same evidence. We're talking about the video where the high-speed chase took place, and I hadn't seen the video. The trial court's saying, if everybody's in agreement on the evidence, then here's my ruling. Is that fair?
I do think that that's a fair understanding of what took place at that hearing.
So if there was a disagreement as to the evidence or the level of evidence, you would have more or a stronger argument? Is that?
I do. I think that if there had been a full-throated challenge to that by defense counsel at the hearing, then this would be a different case.
And what are we talking about? We're talking about a video, right?
Well, it's video and also testimony from at least two people, really just one, Mr. Malone, who was a party to anything that happened in Nashville that took place at trial. And so my understanding of Kirkpatrick and the cases that it relies on, one of which being State versus Gilley, a Tennessee Supreme Court case, is that it's probably not best practice. We're going to strongly caution against making a clear and convincing ruling based on just a summation. But at this level, when we're now on appeal, we have to look at the evidence that was actually submitted at trial to see if it amounts to a clear and unequivocal, to a clear and convincing standard. And our position is that it does not. And because it does not, then a clear and unequivocal rule of law was breached, and Mr. Duncan is entitled to plain error relief. Just one thing that is kind of, to put another distinction, I guess, between Kirkpatrick and the case at bar is that Kirkpatrick, when this court said it's not a good idea to do it this way, we're still going to look at the evidence and ultimately hold that it was clear and convincing. The summary that was provided there, the underlying criminal charges were a burglary and a theft of property. Here we have a murder case and potentially a robbery. And there is guidance both from this court and the Tennessee Supreme Court cautioning that when we are dealing with a case that deals with a potential punishment that involves life in prison or something to that extent, that the prior crime, the prior act evidence should be more thoroughly scrutinized, or you should keep that in mind as you're evaluating that evidence. So I just say that to say that as we're looking at the evidence that was presented at trial to the prior bad acts, for a little bit of context, and the evidence that I see in the record that was presented at trial that would show, that would potentially go to the prior bad act evidence, mostly comes from Mr. Malone. He was with the alleged victim that day. They went to a Thornton's gas station. There was a bag exchange. There was an officer who testified, basically connecting. There were some video evidence, but nothing in that testimony or nothing in that evidence ever shows that Mr. Duncan engaged in the bag exchange. He was not the person who went to the car and gave Mr. Sanders the bag. The police were very clear about that, even though Mr. Malone couldn't say who anybody was. And the video doesn't show who's driving the black Ford truck. It doesn't show, as I reviewed it, doesn't show that there's a shootout, but those allegations are what were brought up by the state. And that was the purpose of that evidence, was to show that there had been essentially a drug deal that took place earlier in the day. Mr. Duncan had been ripped off, and then there was a car chase and a shootout, and then that precipitated everything that happened in Lebanon.
But all of that you're arguing right now kind of goes to the weight of that evidence, how the jury would view it, correct?
So I'm not arguing in this case that that is a jury question. That is the evidence that really should have been presented at the pretrial hearing for the trial court to evaluate whether that's by a clear and convincing standard. And it's my position that that is not clear and convincing evidence of prior bad acts.
Is your argument a process argument, or is your argument that the trial court got it wrong? What are you saying, or are you saying both?
I think I'm saying both, or hopefully I'm saying both. So it's, one, the process. At the pretrial hearing, gold star standard, of course, would be you put on evidence, allow the court to review it, and then it makes a determination based on that. There was plenty of time for that to have happened in this case. These are not far-flung witnesses. It would have been easy to get them to court, that sort of thing. I do think that the trial court, because there wasn't an objection to any of the evidence or a challenge to the state's proposed summary of it, that the trial court could have made a preliminary ruling, at least based on case law and direction from the Tennessee Supreme Court, that it could have relied on that summary. But what I'm trying to say is that it goes beyond that. Because we didn't have any evidence that was actually presented at the pretrial hearing, and because we are now on appeal post-trial, we have to look at the evidence of the prior bad act that was submitted at trial and determine whether that was presented by a clear and convincing standard.
But isn't that the risk that the defendant ran by not challenging it at the 404B pretrial hearing?
I think so, and that's why I'm under plain error review. But it's not that the trial court making a decision off of the summary alone is enough to just carry the day. Because in Kirkpatrick and the other cases that it relied on, this court went one step further, especially in Kirkpatrick, and still reviewed the evidence that was presented at trial to evaluate that, to say, is this clear and convincing evidence of a prior bad act? So what I'm asking this court to do now is the same analysis that it already did in Kirkpatrick. And when you look at the evidence that was introduced at trial, I do not believe that it amounts to a clear and convincing showing of proof that, one, Mr. Duncan engaged in these prior bad acts, and two, that it would have been sufficient to clear that threshold and then be admissible otherwise under 404B.
So trial court first called it a continuing legal or continuation of events because this is where the bag was first videotaped, the text messages confirm that.
That was the state's theory, yes.
Is it not the proof that was put forth, that there were text messages between the defendant and the victim in this case?
We're talking not about the summary now, but at the
Oh, yeah, we're talking about, what the trial court ultimately determined and our evaluation.
Yes, Your Honor. Yes, Your Honor.
And continuation of events, motive.
Mm-hmm.
That's what the trial court hung its hat on, really, motive, right?
So in addition, under 404B, it has to, one, find that there is a non-propensity purpose for the testimony or for the proposed prior bad acts. What I'm really challenging today is the clear and convincing standard, that the evidence presented at trial that Mr. Duncan was engaged in a prior bad act earlier in Nashville was not shown by clear and convincing evidence. Because as I read the record, the only thing that links him to Nashville, I mean, there are these messages and phone data, that sort of thing, but there's Mr. Malone's testimony about what actually occurred at this Thornton's gas station, and that there was his testimony and the video around the gas station and then MAPCO, and I think there's a car wash, is that there was a bag exchange by an individual the police knew not to be Mr. Duncan, that the individual who did the bag exchange then got into a black truck, and that there was a chase, so there was a car chase, and there was a shootout from that, and then ultimately the black truck wrecks out and Mr. Malone pulls into another apartment complex. So my contention is that that evidence was not clear and convincing of Mr. Duncan's involvement in this prior bad act such that it would have survived 404B scrutiny. If there are no other questions about that, I'll move briefly to the sleeping juror issue.
Counsel, how many jurors are asleep? I thought the trial judge made a determination that there was only one that was asleep and that person was excused.
Yes, Your Honor. So at trial, which was in early November of 2022, the judge stopped the proceedings and called both counsel forward and said something to the effect of, I don't normally do this, but there were 4 jurors full on asleep. There's then, I think, an off-the-record discussion that takes place, and it's eventually decided that they'll just turn the lights on and keep moving.
Agreed to by defense counsel.
Yes, Your Honor. And I'll address in a moment why that wasn't a tactical decision, if time permits. But it's my reading of the record and my understanding that there were 4 jurors then full on asleep at that point in time.
The review here is plain error with regard, and why isn't then the trial judge's ruling on the motion for new trial essentially really just in itself defeats your argument on this point? I mean, the trial judge in the motion for new trial comes back and says, you know what, I think actually only one of them was asleep and I got rid of that one, and the other one's just, and how are we going to get to plain error given that determination?
Yes, Your Honor, for just the summary that you gave, where the trial court says, well, I think it was really just one, and we're going to excuse him.
And it was by agreement with defense counsel. That,
Yeah.
to me, is even more significant when you have defense counsel agreeing to the conduct that the trial judge engages in, and then on appeal now, appellate counsel says,
Yes, Your
hey,
Honor.
that was the wrong thing to do.
Yes, Your Honor. Back to the contention of whether
I'm
it's
sorry,
4
go ahead.
or 1, and then I'll try and address that. Because the trial court made that factual determination almost 4 months after the event had occurred, I think the much more reliable evidence is what occurs contemporaneously to what's actually occurring in court. So both I and the state for this issue have relied on State versus Chestnut. And in that case, it's an eerily similar factual scenario. The trial court stopped the proceedings, called both attorneys up, said, I see one juror that is asleep and 3 others that are drowsy. And this court relied on that factual determination or statement in the record to evaluate that issue. So again, I think that because 4 jurors full on asleep happened contemporaneous to what was actually occurring at the trial court, that would be the better evidence of what was actually taking place at that time.
Can I ask a question on that?
Yes, Your Honor.
So in reading the record, what stuck out to me just kind of cursorily, did trial counsel, defense counsel watch a video of the entirety of the trial in this case?
I am not sure, to be honest with you, Your Honor. There is a video. So apparently this court, this trial court is much like this one in that it had video capabilities, and I think that they recorded maybe the entire trial. That was supposed to be in the record and supposed to be
there
filed.
was discussion in the motion for new trial hearing about a 39 hour video that was watched. And it sounded to me as if defense counsel was relying on that video, but there is no video in the record.
Yes, Your Honor. I don't know that counsel relied on the video for this issue when it agreed that there was only one juror that was sleeping, because he did challenge that at the motion for new trial, I think.
No, that's when it was said. He was trying to, I think, for the impression that I got from the record is this trial counsel was kind of offended that his truth about the sleeping jurors was being challenged. And so that is when he invoked the video that someone in his office viewed in support of his position that more than one juror was asleep. And so when I'm reviewing this issue, I'm asking myself, well, where's the video?
Yes, Your Honor. I do believe that that's right. And I know that the video, as far as our claim about the time spent, the judge spending time with the jury outside of the presence of everyone, ex parte communication, that thing, that I believe it's the same video was used to create the timeline of like down to the minute for how long the judge was communicating with the jury. This is all outside of the record at this point.
Well, if it's not in, that was my question.
Okay. Well, just to briefly say, it is supposed to be in the record. It is not, and when I've spoken with the clerk's office, they do not have it. But there is an order from the trial court judge saying that this video is supposed to be kept under seal until the conclusion of this matter, which to me would include appeal. So
if it's under seal, how did defense counsel see it?
He and the state were allowed to check out the video, but the clerk's office was supposed to maintain that video, and that video, again, this is outside the record, but that is gone. I've spoken to the clerk's office. They do not have that. They cannot say where it was, and I don't know why it was disposed of outside of the trial court's order. I'll save the rest of my time for rebuttal if I have any. Thank you, Your Honor.
And counsel for the state, Mr. Lundy? I don't know that I've heard you argue. Nice to see you.
Thank you, Your Honor. It's good to see you as well. You were supposed to hear me argue at one point, but General Ball had to take my place because I lost my voice and I would have been speaking to you like this, and it would not have been good for anyone. So I certainly appreciate this court's flexibility in permitting General Ball to argue in my place in that case, and I am more than happy to be back. Thankful for the opportunity to represent the state today. My name is Will Lundy, and I represent the state of Tennessee in this appeal. As defense counsel has limited his arguments to the question about Rule 404B and the question about the allegedly sleeping juror or jurors, I will limit my argument to those topics as well, unless the court has other questions for me. First, when we're talking about Rule 404B, the Kirkpatrick case does say that trial courts not only can, but frequently do, and just by the nature of 404B issues, they sometimes must, evaluate the sufficiency of allegedly bad acts evidence just on a basis of summary. And that is exactly what happened here. And as Your Honor pointed out, defense counsel did not challenge that evidence. There was no reason to believe that the evidence was anything different than what the state presented. And I guess I'm trying to wrap my head around defense counsel's argument As I understand it, what he's arguing now is that the trial court didn't substantially comply with the procedural requirements of Rule 404B, and that's why, we're bringing in Kirkpatrick and saying the idea that the evidence is or didn't meet that clear and convincing standard results in a failure to comply substantially with the procedural requirements of Rule 404B. If that is indeed defense counsel's argument, I think it's irrelevant because, of course, the remedy for failure to substantially comply with the procedural requirements of Rule 404B is de novo review. But we're not here on de novo review. As counsel rightly concedes, we are here on plain error review. And on plain error review, when we get to the merits of it, the trial court was correct in admitting this evidence under Rule 404B because it was certainly relevant, and in fact necessary to prove motive, and even the defendant admits or argues in his reply brief that the evidence of Mr. Duncan's identity was weak, absent this evidence that came in. So it was relevant and indeed necessary to prove Mr. Duncan's identity. And as the court pointed out, there were some videos and maybe they weren't talked about in the pretrial hearing. I don't remember that, and it also, I don't remember that the text messages were spoken about in the pretrial hearing. But the text messages clearly show that Mr. Duncan and Mr. Sanders, the victim, were communicating on the day of the murder about some sort of an exchange. And counsel used the phrase drug deal. We honestly don't know what was in that bag. There's nothing in the record to tell us, but we can assume it was probably not American cheese or something along those lines. So in any event, when you take into account the fact that the defendant had planned on meeting the victim at Thornton's, I think the evidence is clear and convincing as to what happened that day. Also, if I remember the record correctly, there is video evidence of the defendant walking into the Thorntons, and you can see him inside the store. I was under the impression that the video showed the defendant driving the truck. Counsel disagrees with me on that. This record is so massive that I am not prepared to say exactly where in the record that is. When you look at the videos yourselves, you can discern that as well. Additionally, I will note that in my brief I had to rely on the officer's testimony about what the videos showed because with my technological ineptitude, I was not able to view some of the videos. I was able to view some, but not all of them. So I just have to confess my own inadequacy on that front. But in any event, the record showed that the defendant had texted with Mr. Sanders and they had agreed to meet up. The record showed that not only did the record eventually showed that this black truck was the defendant's truck. So it's no question about whose truck it was or anything like that. Mr. Duncan is seen in the video at the gas station, whether inside or outside. At one point in the record, I believe the video shows Mr. Duncan actually holding this yellow bag or beige or whatever color it is. I'm colorblind, so I can't tell you what color the bag was, but I think everyone agrees it was yellow. In any event, the record shows that he was holding the bag at Thornton's at one point, and then he ultimately gives it to his accomplice, who then subsequently gives it to the victim, Mr. Sanders. And again, that fact that the accomplice gives the bag to Mr. Sanders is something that the defendant and Mr. Sanders discuss, in their text messages with one another. Immediately then, after we have this bag exchange, Mr. Malone in his silver Chrysler drives away, and whether it's the defendant or the accomplice driving the pickup truck, both of these men are in the pickup truck. The black truck chases them. And then there's Mr. Malone testified that someone, whether it was the defendant or the victim, we don't actually know, but one of the two shot at the vehicle, and it was proven that actually did indeed happen because there was a bullet hole in the car that, if I remember correctly, the bullet was lodged in the back of the passenger seat, which is where Mr. Sanders was sitting. Mr. Malone was obviously driving the car. So I would argue that if you do look at the trial evidence, it is clear and convincing as to what happened. And again, on the merits of a 404B argument, it was obviously relevant to prove motive. This killing was about revenge. Whatever happened at Thornton's, and the defendant felt like Mr. Sanders had somehow ripped him off, and the defendant then tracked Mr. Sanders from Thornton's there in Nashville to ultimately to Lebanon, where he shot him twice in the head and killed him. If the court has no questions on that, I'll move on to the sleeping juror issue. Judge Usman?
Usman.
How do you pronounce it? I'm sorry.
Usman.
Thank you. I appreciate that. The judge did find that only one juror was asleep, and that's the only finding of fact that we actually have. I want to point out when the judge spoke in the trial about there being potentially 4 jurors who were full on asleep, that wasn't a finding of fact. It was just a comment. So as far as what happened, I think the best evidence that we have of what happened is the trial court's findings that only one juror was asleep. And as you pointed out, Your Honor, the court excused that juror. And so the defendant simply can't show that any of his substantial rights were prejudiced by that sleeping juror. And insofar as there was a video, and I have to confess, I don't remember anything about this video of the entire proceeding. I don't remember seeing that. I certainly believe you that it was there, but I don't remember it. In any event, we don't have that video, as has been discussed. And insofar as the record is simply not adequate to allow this court to review what happened below, then this argument fails because it's on plain error. I think that is the end of my argumentation. If the court has any further questions, Judge Easter, do you have any further questions? If not, I'm prepared to cede the remainder of my time, and I would ask this court to affirm. Thank you.
Thank you, Mr. Lundy. Mr. Raines, you have your 4 minutes.
Thank you, Your Honor. Just briefly, I'll first address a few issues that the state raised as far as the 404B issue goes. So at the pretrial hearing on this, the state actually argued that it wanted this information to show identity, motive, and intent. And then the trial court said, I'm going to allow it because it's a continuation of events. So
And motive.
I don't recall that it said, I'll trust you on that, but I do recall that it said a continuation of events. In any event, the real contention was the evidence of the prior bad act clear and convincing, and it's our position that it isn't. And so working under the current framework of the case law on this, which is Kirkpatrick, and it relied on Brannigan, and then a Supreme Court case, Gilley, it's our position that in order to evaluate whether the evidence was clear and convincing, you have to look at the evidence that was presented about the prior bad acts at trial, because there essentially was no evidence presented at the pretrial hearing. And again, without belaboring the point too much, it's our contention that that evidence did not clearly and convincingly show that Jonathan Duncan is the one who committed these prior bad acts. And because of that, even under plain error review, we are still entitled to relief.
Didn't you argue earlier, though, that the video really didn't show what was going on, correct? Other than did it really show a bad act?
There were 3 different videos about the Nashville incident. One is at the Thornton's gas station. One is, and the other 2 are of the car chase. One comes from a gas station, and the other one comes from a car wash. So those don't really show, to the best of my recollection and looking at them, those don't really show that Mr. Duncan was driving that truck, that he's the one who shot at the individual's car and Mr.
So what was the bad act that those showed?
The bad acts are, under the state's theory as to why they wanted to use these, was to show that there had been a drug deal that had taken place through the bag exchange, that Mr. Duncan had been ripped off in that, and that then there was a car chase and a shooting that precipitated the events in Lebanon. And so again, I just don't think that the evidence is there to show, even by a clear and convincing standard, that that occurred and that Mr. Duncan was the one perpetrating those bad acts. Moving briefly to the sleeping juror issue, the record, I believe, is sufficient. I don't think that we need this 39-hour video, wherever it may be, to say that there were 4 jurors that were sleeping. The judge made a contemporaneous observation, voiced that to the attorneys at the time that it was made, and they addressed the issue. And there is other evidence in the record to show that the jurors were fatigued before that point. Even during voir dire, there's kind of a joke made about one of the potential jurors. They nicknamed her Snow White. Her real name escapes me, but that she was yawning. And then the bailiff also asked the judge to have the jurors stand up at one point and kind of stretch their legs. And this was all before the state then showed a 2.5, 3 hour video of Mr. Felton's interview. So I think that on that point, the record also shows there is enough in the record to support this case. And again, before I run out of time, we just ask that this court either vacate and dismiss Mr. Duncan's charges, or vacate and remand for a new charge, and then also address the technical issue in the judgments. Thank you, Your Honors.
Thank you, counsel. Appreciate argument and briefing. The matter will be taken under advisement. I think this concludes our morning docket.
Yes, Your Honor.
We'll be in recess until 1:30.
All rise.